When you get into a motions practice where you're challenging evidence, when you're challenging what the government is doing, I think every time you're talking about anything other than the facts, when you don't have the facts, that is your best defense. Sometimes you have bad facts and you still got to make the government prove it, whether it's making them jump over small hoops, big hoops. Pounding the table doesn't always help in front of a jury. It's all about being likable and plausible. The government still has to prove their case at any jury trial. There are cases where I'm going to get my head handed to me and the prosecutor's going to say, we're going to beat you. And I'm like, I'll still show up. I will be there.
Welcome to Hot Docket, the show where we talk about winning marketing strategies that have built the most successful law firms.
Join us every 2 weeks for the latest trends and tactics to grow your law firm. Welcome to the Hot Docket. Today we're joined by Richard Huttner of Richard B. Huttner Law Firm. And we've got a lot to talk about, so I'm going to jump right into it. Thanks for having us today, Richard.
Thank you.
So if you could run through really quick your origin story and why you became a lawyer, it would be really helpful and interesting.
I don't know how interesting it is, but I come from a family of lawyers. My dad was a lawyer, had his own practice, practiced family law and personal injury, and did some criminal defense, which is what I do. And my brother's a lawyer, my sister's a lawyer. And so if I wanted to have any fun at Thanksgiving, I had to become a lawyer.
Can't imagine what those conversations must be like.
It was painful. It's still painful.
Yeah.
Dealing with lawyers is not always fun. And when they're siblings and you have the sibling rivalry, it just multiplies that pain. So I became a lawyer. It's something I always wanted to do. In law school, I thought I wanted to be a prosecutor because I was a pretty straight and narrow individual. And sitting through those classes of law school, criminal defense, criminal procedure, criminal law, just kind of made me angry. Not necessarily with anybody in particular, but with the system as a whole and the fairness to the little guy. And so my first job during law school was a law clerk for a general practitioner who did a little bit of everything. And that wasn't much fun because it was just arguing about money. And then I worked for a personal injury attorney and learned a lot, learned what I didn't want to do, and that is fight for money because the passion wasn't there. And so when I graduated, my dad said, well, why don't you try becoming a prosecutor? I said, no, I don't want to do that. Let's just start doing criminal defense. So I advertised, and back then in 1993, advertising wasn't on the internet. It was on newspaper ads, phone book, TV guides. And so I put a small little ad in the TV guide, and slowly cases started coming in. And for the first 2 or 3 years, it was a struggle. And then finally, I was able to afford a quarter-page ad in the phone book. And then, more cases came in, and it just started to ramp up. And finally, the phone book guy said, we're getting rid of phone books, and you think that's great because you're not going to have to pay all that money because getting on the internet was cheaper. Now I will tell you that advertising on the internet is far more expensive than it ever was in the phone book.
Bloodbath.
Yeah, they didn't have you in a Dutch auction to appear at the top, driving the cost per click through the roof back then, did they?
No, they did not. It was the personal injury guys had the back cover and the center of the phone book, and personal injury covered probably most of the revenue for the phone book. And finally, when you got back to the criminal guys, they could maybe afford a half page, quarter page, eighth of a page. And, that's how it all started. And I really got passionate about helping people in their time of need. I've always been a fan of helping the underdog. So it was easy to root for the underdog. And so it was a natural place for me. And I've had a lot of fun. I've been doing this 30 plus years, and I would say that every day is enjoyable. I see a lot of stories. I hear a lot of bad things, people that go through tough times. And at the end of the day, I'm able to help make their lives a lot easier, and oftentimes put the screws to the government to make them prove their case.
Richard, do you handle both white collar defense and like non-white collar defense type of stuff?
I don't. I just do street crimes.
You just do street crimes.
The number one crime in America is driving under the influence, DUI. So Colorado, on average, has about 38,000 DUIs a year throughout the state, and other states have similar large numbers. So that's the number one crime, and that's why most criminal defense lawyers start with DUIs. I enjoy assaults, sex assaults. Those are entertaining, and oftentimes people find themselves in a situation they never expected to find themselves in, and they have to act what they think is prudently, and they get charged. And when in essence what they did was what anybody else would have done, and that is defend themselves, defend their friends, defend their wives, and fight back, and you're allowed to do so. Cases of child abuse, parents are allowed to discipline their kids, and the government comes in and tries to call it child abuse when the school nurse or the teacher sees a spot on little Johnny's arm or on his leg or on his butt, and they come in and say, well, you can't discipline your kid and leave a mark. Well, no, you can. That's as long as it's reasonable. And so I had a little bit of a specialty doing child abuse cases. I went to trial on horrible cases, and my clients ended up walking out. And it was always the similar line I used is, these are parents that care enough to discipline their kids.
How hard is it for you to separate what you hear a lot with criminal defense, at least what I've heard, is you're not necessarily, of course you're defending your client and advocating for them, but you're also defending their rights and what they're entitled to as a citizen and yada, yada, yada. So how hard is it for you sometimes to separate the person from, your duty as an advocate?
Well, it's hard when these people are paying you. So when I always look over to the public defender, and I always tell them that, remember that these fact pattern are widgets. So if you ever took a business class in college, you always talked about widgets, just items. And for lawyers, these fact patterns are widgets. And so you try not to get too attached to the person because you lose perspective. And so I just say, just focus on the fact pattern.
You know why that's very interesting? Because we talked to a defense attorney earlier today, and one of the things he said is the thing that separates us in many cases from the public defender is that we take the time to learn and care about our client and form deep relationships. So I'm not saying that he's right and you're wrong, or you're wrong, you're right and he's wrong, but I think it just shows kind of the different ways that people can be successful in your role and how you can get through it and be the best that you can be as a defender.
Right. Private attorneys do have the time to get to know our clients, get to know the fact patterns, get to return calls to their relatives, get to listen to the whole story, where the public defenders don't have that luxury. They have too many cases. They have 25 to 30 cases showing up on their desk every Tuesday, and they have to get rid of most of those cases because the following week or 2 weeks later, another 25 or 30 cases is showing up on their desk. Private attorneys don't have that type of volume, at least they shouldn't, because they do need to get to know. But if you're going to argue and do your best possible job for your clients, you have to get the emotional tie away. That even though they are paying you, doesn't mean you have to ultimately buy everything they say. You have to do what's best for them, looking at the entire picture. Now, the great Jerry Spence, who just died a couple weeks ago, the great lawyer from Wyoming, he always professed that you had to become one with your client. You had to get so interactive with your client that you are him, and that's how you do your best work. And what I found is that may have worked for him, but you lose perspective sometimes. And sometimes you got to have that out-of-body experience and looking at all the different angles that a jury is going to look at it. And so understanding a juror's perspective makes me a very effective attorney in being able to communicate to a jury.
When you're picking jurors, are there any big red flags for you when making that decision?
Depends on what the case is. I like juries. I love jury trials. I like communicating with jurors. It really depends on the case. On sex assault cases, where I have a male defendant and there's a female victim, alleged victim, I always like older women because older women are very judgmental on other women. Women are tougher on women. They're tough, and so they may not like what the woman was wearing. They may not like that she drank a lot of alcohol. They may, they will prosecute that victim, which helps my client, and they will, it may not be intuitive that a woman's going to be hard on a woman, but it is. Women are hard on women.
What's your opinion on relatives of cops?
Relatives of cops, depends what kind of case it is. A lot of cases, you want that because they're law and order and they think there's a reason and a rhyme. And as long as you're not beating up the cop, I think they're okay. They're not perfect. But cases where you beat up the cop are like DUIs. Because a DUI has that officer as the main witness. They did the stop. They did the observations. They did the field sobriety test. They oftentimes were there at the blood test or the breath test. And so the judgment and observations of the officer are paramount in a DUI case.
So
the flip side of that is officers only look for reasons to convict, and they never notice the good things in a DUI case. So sometimes you can make them your friend, but oftentimes in DUI cases, they're your enemy. So you don't want necessarily to have a relative of an officer on your jury.
What sort of jury are you looking for a DUI case?
Want someone similar to my client. I want, if it's a truck driver, I want truck drivers. I don't want parents of little kids. I want happier people. I don't want divorced people. I don't want older people. Older people have too much perspective. I want younger, similar to my clients. I want people that drink, people that understand that if you went to a football game and if you were not allowed to drink, that little football stadium would become a temporary jail for hours and hours until everybody had sobered up. So people that understand that it is okay to have a drink with dinner and to drive home, and that's not driving under the influence.
I get the feeling that you have a really deep intuitive understanding of who you want on these juries based on what happened. How much of that did you learn in schooling versus learn on the job and pick up?
I'm better and better picking juries. Each jury I pick, I get a little better and a little better, and that's probably why they call it the practice of law. A lot of lawyers are just so afraid of the process of jury selection. They just can't wait till that first hour or 2 hours of a jury trial are done, and they've picked their jury. They don't really care. They just want to get through the process. When I first started practicing, I would try to memorize the name of every juror, and I would focus so much on that I would not really listen or hear what they were saying. And so I've simplified it. I want to get the jurors, prospective jurors, to talk. I don't want to talk as much. If you watch jury selection, most defense lawyers don't know when to shut up. They do all the talking, trying to get them to agree with everything they said. I just want to get in a conversation and hear about if they're happy in life, where do they get their news? What would they rather be doing than the job they're doing? Just those small things you can kind of pick up on a juror, and they'll get into conversations and topics that you wouldn't expect, and you just learn about them. And then you can kind of get an idea of, all right, would I want to sit down with this person for 2 or 3 hours and talk about facts? Because ultimately, that's what they're going to be doing with their 5 or 11 other people.
One thing I've been thinking about is to take a roundabout way to get there. I've been doing a lot of reading recently on like the practice of selling and the science of selling, because it's not something that's intuitive to me. My background is computer science, done a lot of marketing, but I never took business classes. I've never been in a sales job. I've never done any of it. So I've been trying to learn about that process. And one thing that comes up often is this concept of getting little yeses towards the end goal of getting the big yes, right? So like many small agreements along the way. Does that apply to your work in like a jury trial as well? Like getting many small yeses and convincing the jury of many small yeses to get to that big yes?
They say that in the marketing classes that, when you create your cross-examinations to get the witness to say yes, 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 that the jurors are going to go along with yes. So I do try to go along with that. I don't know if it works or doesn't work. I try my cases on being practical, and if the evidence doesn't corroborate with the story, then the jury's not going to necessarily buy it. And so, there's going to be two stories. It's about likability. If you can make your witness be likable, or if you can make the victim in a domestic violence case be unlikable, you have a shot. And really, while it may be proof beyond a reasonable doubt, oftentimes it's whose story or who do they like better. And that's just a practical element of jury trials and human behavior.
I feel like I'm maybe overusing this particular point a lot now, but I'm going to do it anyway. We spoke to a lawyer a while ago, and something he said, which has stuck with me, is if you have the facts, pound the facts. If you have the law, pound the law. If you have neither, pound the table. Which do you find yourself doing like most often in your cases?
In a lot of cases, I think when you get into a motions practice where you're challenging evidence, when you're challenging what the government is doing, I think every time you're talking about anything other than the facts, when you don't have the facts, that is your best defense. So when you get the government trying to vouch for a witness, or try to keep a witness out, or trying to keep an expert out, and you're not talking about the facts of the case, that just is burning their energy. And so it's making them focus on other things than their facts. So sometimes you have bad facts and you still got to make the government prove it. And so whatever way to do that, whether it's making them jump over small hoops, big hoops, pounding the table doesn't always help in front of a jury. It's all about being likable and plausible, and the government still has to prove their case at any jury trial. The government, it's tough to put on a trial. So there are cases where I'm going to get my head handed to me, and the prosecutor's going to say, we're going to beat you. And I'm like, I'll still show up. I will be there. Okay. I don't mind banging my head against cement. They still have to put on their case. They still have to bring their witnesses. They still have to bring their experts. They still have to get testimony to the finish line. And oftentimes things happen. It's the litigation gods. They sometimes, an officer has a tragedy, can't make it to trial. A technician isn't able to testify on that day because her kid's sick. And so they have some type of hiccup in their case. And amazingly, you get a better offer on the day of trial, or even during trial, because there's a problem with their case. And so, sometimes you got to sit through it, and sometimes they can put on their case and you end up dead in the water. And sometimes good things happen. That's why it's never over till it's over.
All right. Well, I think that's a good segue for us to call it on this one and make it over. I'm also going to pull away litigation gods as a takeaway from this episode. Love that. Thanks for joining us, Richard. I think this was an informative episode. Learned a ton. We'll put links to your site, to your firm, and get all that stuff in the episode links so folks have it. Thanks for joining us on Hot Docket, and we'll see you on the next one. We hope you've enjoyed this episode of Hot Docket. We're your hosts, Bobby and Andrew, founders of MeanPug, the marketing agency for ambitious law firms.
Have questions about marketing or anything we covered today? Email us at mark@meanpug.com. Be sure to subscribe to learn more. Until next time.